To get the program moving, I'm going to introduce all three of our panelists at the same time rather than introducing them individually as they come up to speak. Kabi Caputo is immediately to my right, and Kabi is in private practice. It's primarily devoted to higher education law, and in that regard, he represents a number of community college districts and has done so for many years. Kabi is also an elected member of the Cedar Park City Council. The thrust of his remarks will be on open government. To Kabi's right is Donna Cornell. Donna is the General Counsel of the University of Houston System, and previously she was with the Office of Attorney General as the Deputy Chief in the General Litigation Division of that office. She has been at the University of Houston for 15 years. To her right is Fernando Gomez. Fernando is the longtime General Counsel of the Texas State University System. Fernando has actually been the General Counsel there for some 27 years total. He has also served as the California State University System General Counsel. Before getting into the general counseling business, Fernando attained tenure and was a teacher, a professor at Michigan State University. He also holds a PhD in American culture. Please welcome our three panelists. Fernando is going to lead off the discussion, and he's going to talk about the responsibilities, among other things, of governing boards.
Thank you, General Counsel. Franz, it's always a pleasure to be with you. The directors of the coordinating board, thank you for hosting us, and Dr. Smith and others, for Dr. Gardner, for having us here. Now, I feel obligated to tell you a story. I don't know, I can't recall which one I've told you before. Did I tell you about my wife's grandmother? Well, when I start taking myself too seriously, I think of this lady. She was a woman who was raised in the rural areas of New Mexico along the Rio Grande, about 50 miles south of Albuquerque, and her husband died when she was about 36 years old, and she raised 5 daughters by herself in that austere environment. By the time I met her and married my wife, we were undergraduates at the University of New Mexico, the lady was living on $89.23 a month in Social Security and living with my mother-in-law and her husband, my father-in-law. And we were having a family gathering for my commencement from the university and my brother-in-law's commencement from high school. And she comes up to each of us and she hands us an envelope. This is a very religious lady. And I open the envelope, and there's a religious card wishing me well, and a holy card. You know what a holy card is? It has a picture of a saint usually, and then something on the back. It's either in memoriam if it happens to be a funeral card. And a nice note signed to Abuelita, your little grandmother, AUR, her initials, and a 20 and a 5. And my brother-in-law got the same gift, and I was very touched that she treated me just the same as she treated her grandson. My wife and I had been married about a year. And then when I finished law school, she comes to me there in the summer, and she brings an envelope, and I tell her, "No, Grandma," I'm telling her in Spanish, "no, this is really not necessary." But she says, "No," she presses it into my hand. She says, "I want you to have this." And I open it up, and there's the religious card, the holy card, and the holy card, and the note telling me how proud she is of me, and the signature to Abuelita, your little grandmother, AUR, Aurelia Olivari Romero. And when I finished the PhD 4.5 years later, she comes up to me. She's a little lady, about 4'10", and she's standing like this with her hand on her hip and tapping her foot and waving the envelope, and she says to me, "¿Cuántas veces más vas a graduar tú? How many more times are you going to graduate?" And I said, "Abuelita, this is the last time I received my doctor." "Eres doctor?" Yes, I'm a doctor. I received my doctorate. Sabes que tengo un dolor aquí. That's such a pain in my arm. She could never understand the utility of a PhD, but God bless her. Anyway, three themes resonate when we talk about trusteeship or being a regent, becoming a regent. And I want to talk about these three themes, but I'm going to intertwine it with the materials that you have in your packets. But the three things that I want you to come away with is, A, some understanding of the nature of the enterprise, the nature of what you're getting into. How many of you are first-time regents or trustees? A fair number. How many of you are serving within this is your first 2 years or first 3 years, say? Okay, so this is a fair number of fairly new trustees. So I want you to understand the nature of the enterprise. 2, we're going to talk about the duties, particularly fiduciary duties that the law imposes upon regents and trustees. And thirdly, I want to talk about how those duties are discharged. And 2 points I want to stress in particular, and you will hear these themes throughout my presentation. And the first is the notion of independence, and the second deals with the interactions that you will have as a regent or trustee. Let's talk about the nature of the enterprise. What you're getting into is, and what you are in, those of you who have been regents or trustees for a while, is an institution that is very, very unique in our culture. In many ways, it dates back to colonial times. And there were charters that the British Crown gave to the colonies. Harvard had probably one of the earliest charters, having been chartered, I think, in 1640 as an institution. I want to tell you a story of Dartmouth College, which was chartered in 1769. Now, when the Crown gave these charters, in Dartmouth's case, they wanted to start a school for Native Americans where they could teach them and educate them, and in particular teach them about the Christian religion. And so the Crown gave them a charter. People donated money, they donated land, and they established this school, which ran it's still in existence today. As it happens, around 1815, the New Hampshire legislature passed a law that made Dartmouth College public, and the trustees of Dartmouth College, in a case called Trustees of Dartmouth College versus Woodward, that was decided by the U.S. Supreme Court in 1819, sued, and they said, "You've taken our property. You've taken these resources in this land that we have built and that we continue to run and to operate." And their lawyer was a man named Daniel Webster, a great advocate. And they went to the U.S. Supreme Court, and Justice Marshall decided the case. And he basically said that under the United States Constitution, Article 1, Section 10, that declares that the state shall not make any law impairing the obligation or the right to contract, and then proceeded to say that the Dartmouth Charter was not undone by the Revolution, by the American Revolution. What's extraordinary about the Dartmouth Charter is that it laid out and it granted to the trustees the power to make rules and regulations, the power to acquire land, the power to sell land, the power to accept gifts, the power to hire presidents and to create officers of the board. So the fundamental structure, as we have exemplified in Dartmouth College, which I think precedes Dartmouth College, is what we live with today. And even though the state of New Hampshire lost that case, what it did is it solidified the concept of an independent board of trustees, an independent board of regents. Now, some of you are elected, and I want to talk in your handouts. You've got fundamentally two handouts for me. One is a statute, and the other is titled General Authority or Duties and Authorities of Regents and Trustees. But you are appointed by the governor, if you're a regent, with the advice and consent of the state senate. That means that you're a state officer. You may be removed generally through impeachment. You should respect and listen to the governor that appointed you, but your job as a regent and as a trustee, if you're elected, is to exercise your best judgment for the overall good and benefit of the institutions that you serve. Now, there are people that might the Association of American Governing Boards, for example, believes that the regents and trustees should also advocate for higher education, and as a general rule, that's true. But we have in Texas the Higher Education Coordinating Board, whose job and mission is the overall, the oversight of higher education in the state of Texas. So if you're a regent or a trustee, your primary responsibility is that Board of Regents. Now, what duties do you owe the board? You owe a duty of loyalty. So the governor picks up the phone, and this happened, I want to tell you, in a galaxy far, far away at a time long, long ago, when I recall that a governor, nobody who's alive today, called and insisted that a certain individual be made chairman of the Board of Regents. And the chancellor, of course, was put into a quandary and said, you really need to talk to my board chair. And called the board chair, who had been an appointee of that governor, and said, I really think I need for you to make this person the chair of the Board of Regents. And that regent said, well, Governor, I'll tell you what, the board feels differently, and we have a candidate other than the one you've selected, and we thank you for your insight and for your input, but that's where I think this board is going to go. I can't predict it, of course, but I think that's where this board is going to go. And that was a tremendous act of courage to say to the governor, wait a minute, we think we have somebody else. And the governor pressed him, and I heard half of the conversation because I was in the chancellor's office with this chancellor and this regent. And the regent said, well, Governor, if you want my resignation, you can have it this afternoon. The individual was quite prominent in the state, as many of you are, but the governor backed off and said, well, you exercise your judgment. That's what you're supposed to do, exercise your judgment. Not your individual judgment, but your collective judgment. So you owe your duty of loyalty to the institution, to the board. Secondly, you owe a duty of unity. And the duty of unity is, and Kabi will talk about this in a minute, there's only one way that a public board can act: at a properly noticed public meeting with a quorum present by majority vote where the matter has been posted. And that's how you vote. What you think as an individual is important around that table, it's going to hold sway, but you are not the board. I like to tell the story. I think it was begonias. It may have been pansies. I don't know what it was. But there was a campus, one of the campuses, the president had and the grounds crew had begonias or some flower posted or planted around the tennis court. And one of the regents came along and said, gee, that's not really what I prefer. I really am partial to pansies or whatever it was, tulips, doesn't matter. And sure enough, next time she showed up on the campus, the flower bed had been torn up and the tulips had been installed. Well, be careful what you say. People are going to listen to you, and they're going to want to be responsive to you. And so if you have a son-in-law that you think is absolutely brilliant and would make a great professor and just got his degree summa cum laude from the University of California at Berkeley, and you want the person to get a shot at an appointment, be very, very careful. That's use of undue undue influence. You don't get to make personal calls. The thing I would say also in terms of the nature of the enterprise that I think is surprising to a lot of people, and that is that what you're going to encounter is, as I said, a tradition of centuries of independence, but you're also going to encounter the most unusual institution you will have ever encountered in your life if you've not been in higher education. Many of you are in businesses, you're in the professions, you work with companies, but a university, what you're going to encounter is you're going to encounter something called academic freedom. The notion that people can speak their piece on matters of significance sounds like the First Amendment, but they're going to have people that are going to give you pushback on the things that you say and the things that you do, and are going to criticize, and that could cause a problem for some folks. There's a notion of lifetime appointments. Many people on my board, for example, understand that if they make a decision in their companies, I want this done, it's done. Doesn't work that way with the university or university system. You can't decide you dislike somebody or you dislike something that's been said or that's in the papers, and you're going to do something about it, and you're going to do something about it now. Thirdly, the concept of shared governance. That's a beaut. That's the notion that the faculty want to and feel entitled to, and I guess culturally and historically are entitled to have some say in what the institution, how the institution is run, at least with respect to the academic part. And so you may find a president that is very responsive to the faculty. That's not unusual. It doesn't mean they're not responsive to you. That means these are the stresses and strains that the presidents are undergoing. The concept of public accountability. You're going to have to operate in the sunshine, and Kavi's going to talk about that too. And what you do is going to be simulcast all over the state and beyond. So, if any emails you send, any advice you want to give the chancellor or the presidents, and you shoot an email, those may well be subject, as Kavi will talk, to the sunshine. There are public expectations sometimes to correct private problems. Somebody may write you and tell you a horrible story of woe, a terrible story of some injustice that's happened to his or her daughter on the campus or has happened to him or her. And it had a thing involving hazing a couple of years ago, and it just sounded horrible. And of course it got a member of the board very upset. Why are they picking on me? Well, because you're an alumnus of that school. And so they see your name on the website, they're going to write you. And you don't need, that's not your job to solve that. It's your job to let the president or the chancellor know and then let them deal with that. If you want accountability back, we'll let you know back what happened. There was absolutely nothing to those allegations, but yet people feel that, and it's in the First Amendment, the right to petition the government for redress of grievances. You have no individual voice. I've talked about that. You do at the boardroom, but in terms of a vote, and then there's concepts of process. You know, a professor does something horrible, horrible, grievous sexual misconduct. You can't just fire a tenured professor. You have to go through measures of process. These are things that all of us who have worked in higher education and who have spent a career in it have come to learn. And so keep in mind, you've achieved, many of you, great distinction in your jobs, great distinction in your companies and in your professions. You've been very successful people, why you've got the attention of the governor and why you're sitting here today. But the presidents and the vice presidents and the general counsels have also worked at their trade for the last several decades, and so rely upon them. If you lose confidence, make a change, but rely upon them. I want to talk now the duties of the chair. I want to say the chair has the right to provide leadership and give everyone a voice. If you have a dissenting voice and you must accept the decision of the majority, you should accept it gracefully. But the law also allows, and this is in your materials, allows for you to make a statement and to have it put into the minutes of the board if you disagree. So if something that you feel really strongly about, the board's not with you, you still have the right to speak your piece. Confidentiality, you have a duty of confidentiality. In terms of the duties, you have the right to speak, you have the right to, the duty to listen and to respect board decisions, you have a right to dissent, as I've said, and you have a duty to respect the confidences of the board. I can tell you that in terms of the fiduciary duties, since we're on the concept of duties, the statutory materials from Chapter 51 of the Education Code that I gave you is I think very instructive. I've given you what the law is, and then I've also given you a summary of what it is. But your fundamental duties are as follows, and the law says, Texas Education Code says, it is the policy of this state that the governing boards of institutions of higher education, being composed of lay members, shall exercise the traditional and time-honored roles for such boards as their role has evolved in the United States, and shall continue the keystone of governance in this regard. Each governing board, then you have several duties. The first and the most important of one is to preserve the institutional independence of your board. The right of the board to manage its own affairs through executives and employees of the board's own choosing. And I hesitate to, I don't want to talk about individuals, but not even a presidential proclamation, if it does not have force of law in Texas, or an attorney general's proclamation, or a gubernatorial proclamation, which may not have force of law. Your responsibility is to look after those institutions and to make your collective best judgment. So preserve institutional independence. And the legislature has said it, and the governor at some point signed this law. And this has been on the books since 1987. Secondly, you have to enhance, you're charged with enhancing the institution's public image, and to do what you can to enhance that public image, again, working with the president and his or her staff, chancellor, his or her staff. You are to act, thirdly, as a liaison with the community. You have friendships within that community. That's one of the many things that you have to offer. The wisdom, the knowledge that you've gained in your profession, the wisdom that you've learned in life, that you've acquired in life. Resources, whatever resources you have, either resources of the mind or financial resources or whatever those are, but these are things that are very valuable for you to contribute to the, to the board. It's a job. It's a job unlike any other, and it requires serious study. You come to the board, and I can tell the regents that have read their materials, and they ask the appropriate questions, and they may not understand the intricacies of public higher education financing. I know very few people that do. I know I don't, but they're able to ask questions and engage, because you are to make these universities and these executives accountable. It's not that you can't do their jobs, but you're to make them accountable. You should nurture each institution and help in the statement of a clear mission. Let me talk very briefly, I'm almost at the end here, about the examples of policy decisions. Your role is a policy-making role. Opening a satellite campus, that's a policy decision. That's something that the board has to be consulted on. Opening a new academic program, that's something that at least in our policy, board policy, the board has to approve. And I don't believe it could come to the coordinating board before having that approval. Hiring a president or chancellor, some people say that's probably the most important job that a board does. Because you're selecting somebody that you're asking to lead you. And that's a daunting task, because so many of you are so distinguished and so knowledgeable in your own right that basically submitting to the leadership of another is a very important thing that you do. Whether to sell land on an interstate, whether to ground lease land versus selling land. We had an issue in Austin here involving University of Texas at Austin and golf course and 340 acres that had been given to them, I don't know, a century ago. And the debate was, well, what do we do with that? And there was some pushback from the city and from locals and so on. That's a poor decision. And it's a difficult decision. Revocation of a degree, we've been through that at some point in the past. That's a board decision. The issuance of bonds, the indenture of the institution. What's not policy is termination of a vice president or dean you don't like, or student discipline. Somebody gets disciplined, and the hazing penalty is not enough in your view. Well, that's something you have to live with. That's delegated authority. Speech on campus, oh my gosh, that is a big one. I mean, everybody's for free speech until somebody else says something they disagree with. Then all of a sudden, we don't like this thing. Shut it down. You can't shut it down. Once you've got a forum, you've got to respect that. That's who we are as a people. That's who we are as Americans, and that's our legacy. That's our heritage. That's our great, in my opinion, great contribution to the advance of civilization. The notion that we are going to abide by a set of laws and set of basic principles, and that we're not going to compromise those, whatever that might be. Decisions as to curriculum, on textbook use, strategies on retention. These are not board decisions. Finally, I want to say that Donna's going to talk about ethics, and the reason we talk about ethics and the reason we're having these presentations is one very simple reason. You have power. You have authority. What you do as a body corporate impacts a lot of lives. It makes a difference in people's lives for the good or for the bad. And that's why I urge you as you approach, and I hope that you have great success in your duties as regents and trustees. And I urge you as you approach with great seriousness. And I know that you do, and it's just a grave responsibility that you have been given, and I wish you every success. And I know that if you have that success as a regent and as a board, that your universities will prosper and we'll have a better Texas. Thank you.
Thank you, Fernando. Great job. I'd now like to ask Kabi Caputo to come up, and as I mentioned earlier, the main thrust of his remarks will be on open government.
So we go from Fernando talking about your duties and what kind of good you can accomplish and all sorts of high-level discussions to kind of a very mundane and hyper-technical legal area. So kind of get down there with me. So we're going to start by talking about the Open Meetings Act. I will mention there are two publications from the Attorney General of Texas that you can get on his website. One of them is about open meetings, and the other one is about the Public Information Act, Open Records. Are they in the material? Okay, good. Yeah, they're on the flash drives that you have. So the fact that the Attorney General issued several hundred pages on these topics should let you know how technical it can become. So if you have questions, obviously talk to your lawyers, talk to your staff. You can read the book yourself and maybe get answers. So as Fernando mentioned, you can only act as a body when you're in a meeting. And so that raises the question of what is a meeting? And the law is pretty well defined. It doesn't mean much when you first look at it, but that is the definition of a meeting in the Open Meetings Act. It's deliberation between a quorum of a governmental body or between a quorum of a governmental body and another person. And I highlighted that because you need to think about that for a minute. It's not just when you're talking to each other, it's when someone is talking to you. during which public business or public policy over which the governmental body has supervision or control is discussed or considered, not acted on. You're just discussing it or considering it. The next clause is, or during which you take formal action. So the first thing you have to realize is that for purposes of the Open Meetings Law, it's not just when you take action. It's when you are talking about public business with a quorum present, or when someone is talking to a quorum of you. So obviously the next question is, what's a quorum? The law defines that for us as a default. It's a majority of your board. So most community colleges have 9 members, so if 5 or more of you are gathered, there's a meeting. Some organizations, either in charters or in their originating statutes, may have a different definition of quorum, so you probably want to double check on that. But as a general rule, if you ever look up and find yourself standing with 4 or more people with whom you serve on your board, you might want to consider whether or not you're perhaps in a meeting unintentionally. The Attorney General has expanded this definition a little bit. You look at it and it's like, okay, well, as long as we're not all there. But the Attorney General has defined something called a walking quorum, where I come over and talk to Bill, with whom I serve, and then Bill goes over and talks to Donna, with whom we serve, and then Donna goes over and talks to Fernando. That's actually, I guess, what we would call a serial quorum. None of us were ever together at one time, but the information was transmitted to a majority of us, and that's what the AG has called a serial quorum. A walking quorum is where a couple of you go talk about something, and then you go and talk to some other people, and eventually you round up enough of you that you've walked around and talked about the topic. And so everybody knows, or at least a quorum of you, a majority of you, know what the rest of you were thinking on something. So that would be that walking quorum. And then now, because computers have made our lives so much better, we have electronic quorums. So if you all start communicating by email or by text message, or if you're posting on each other's Facebook pages, and a majority of you suddenly are posting on each other's Facebook page about something that has to do with your organization, that could be considered an electronic quorum, and that too can lead to the troubles. And we'll get to the troubles in a few minutes. So I just want to point out that in addition to what Fernando was saying, the Southern Association of Colleges and Schools, which I think is the accrediting organization for everybody here, they have standards about governance, that the board is to set policy and to oversee the administration and to leave the administration to actually operate the educational institution. So be aware, we're also sort of at a higher level, even beyond Texas law. We're talking about it could jeopardize the college's or the university's accreditation if the SACS people, when they come to do their review, determine that the board is meddling, as we like to say. So that can be, again, the whole board doing it. That can be a chunk of the board. That can be just a couple of board members. I've seen where SACS has written up colleges specifically about a particular member who is meddling, and the rest of the board is not doing anything about it. And that becomes a whole nother conversation, and we could have a whole conversation about that. So the other thing that's in the definition of meeting that we need to think about is deliberation. That's a word that all of you probably have a general understanding of, but we're talking about the law, so the law defines that for us a little further down. So deliberation is a verbal exchange, which would seem to indicate that maybe we can have an electronic quorum, but the Attorney General passed that a long time ago. He just said we're not going to get hung up on that. The intent is you can't communicate with each other. So where it says verbal exchange, now you just insert communicate. During a meeting, which is odd because the definition of meeting says deliberation. So we have a circular situation going on here. The definition of a meeting is you're deliberating. The definition of deliberation is you're talking during a meeting. So between a quorum of a governmental body, and again, or between a quorum of a governmental body and another person, again, concerning an issue over which you have jurisdiction. So I can't stress that enough. That was a change that came in the late 90s where they added in this communication from another person. And that really has, it creates a lot of conundrums. So that's all the slides I'm going to use. I just wanted to put those actual definitions of meetings in front of you. There's another definition of meeting where the organization, the governmental body, calls a gathering, we'll call it. And at that gathering, you have a quorum present. And during that gathering, there is a discussion of public business. That can be a meeting. So think about in the community college world when we have elections, you know, if your institution sponsors debates or something like that, and there's 2 or 3 of you who are up for election up on the dais debating, and then a couple more of you just come along because you want to see what's going on, potentially that's a meeting. And what we do is we like to, at the administrative level, so we can support you, is tell us if you think a bunch of you are going to show up at a meeting that's not a specific, you know, it's not really a board meeting, it's just a meeting of the college. Let us know, and then we will post what we call a prophylactic posting, which just says a majority of the board may be present at this meeting, no public business will be discussed other than what's being presented, and no action will be taken. And then we're clean. So the public knows, oh, well, a bunch of you may be at this, you know, town hall or whatever you want to refer to it as. So the posting requirement is something that you don't have responsibility for. Your administration is going to do that, but just be aware because people will snap at you in meetings, especially for you new folks. You may have just sort of started talking about something, and the lawyer or somebody will say, we can't talk about that. It's not on the agenda. If it hasn't been posted 72 hours before the meeting, the board, the organization, the quorum is not allowed to discuss it. So there will be times that we will, I particularly as the lawyer will say, you're going to have to save that for another meeting because we just can't talk about things that aren't on the agenda. So that leads to a challenge in the world of citizens communications. Most of you have a citizens communications or a public forum or something like that in your normal meeting agenda. And it used to be fine. The public would come and they would talk and you could argue with them about what they were saying, and it wasn't necessarily on the agenda. And when the law changed to say when you receive information from a third person, the Attorney General issued a ruling saying you can't have citizens' comments anymore because a quorum of the board is receiving information from a third person when that citizen is there complaining about something. A whole bunch of governmental bodies complained about that and said, but this is a time-honored tradition. People have the right to grieve under both the U.S. Constitution, as Fernando mentioned, under the First Amendment, and under the Texas Constitution. So you have to let the public come and talk to their elected officials in particular. It may be less of an issue for those of you who are appointed by the governor, but certainly the elected officials have a hard time when someone comes and starts talking to them saying, go away, we don't want to hear from you. So he retracted his original opinion and issued another one saying, well, it's okay if they come talk, but you can't talk to them. And so that's why a lot of organizations will, when citizens' comments is called up on the agenda, while they'll say, you can talk to us about anything you want, we're not going to respond. And it's because the Attorney General said you can't. Again, it's not because anybody wants you to not be a good elected official or a good representative of the institution. It's not that we're not interested in what the public says. We're just not allowed to talk about it because it's not on the agenda. Unless they're talking about a topic that's actually on the agenda. So if it's something that's on the agenda, you know, the presiding officer can say, that's a later topic on our agenda, and you can either call it up then and say, we'll have a conversation about it with you, or you can say, why don't you wait till we call that agenda item and then come back and talk about it? There's ways to handle it at that point. But by and large, the people that come during citizens' comments are not there to talk about, I don't know why, but they never want to talk about what's actually on the agenda. They always have some other agenda that they're carrying and they want to come talk to you about. And a lot of them leave kind of miffed because, you know, they've kind of screwed their courage up and they're going in front of a body of appointed or elected people, with all this power radiating around you. And, you know, in halting tones, they tell you what they're complaining about and you all just sit there and stare at them. And they walk away, and it's horrible. But it's what the Attorney General has created for us based on the way the legislature has defined meeting for you. So that's why we go through that. There are a couple of exceptions. If you all just gather for a social event, want to have a Christmas party and you all are present, that's fine, provided there is no discussion of public business. And, in a large group setting, that's probably okay. My city's going to have their Christmas tree lighting tomorrow, so all of us will be there. It's a social event. We all know, don't stand around and talk with each other about public business. We just talk to the public or whatever. But, I've known organizations that say, well, we're going to have a board Christmas party. And it's just the board members. It's at one of the board members' homes, and it's like, I'm just having a Christmas dinner for people I know from work, basically. You can do that, except it looks bad. Some people may talk. Some people may say, well, how do we know that you didn't talk public business while you were there? Well, you weren't allowed there. The media wasn't allowed there. It wasn't being broadcast on the internet like your meetings are. So it can lead to trouble, and you just need to bear that in mind. I try not to get too prescriptive with people about what they can do in their own lives. But a social gathering where no public business is discussed is okay. It's just, how does it look, and how do you guarantee that there isn't public business discussed? One way is you self-police. I mean, if you hear a couple people over in the corner, starting to talk shop, somebody might want to wander by and say, why don't you come over here and have another glass of wine and quit talking about that? And let's keep this social. So that's okay. You're also allowed to attend, without posting it, a regional, state, or national convention or workshop. So there's probably various national conferences and conventions that groups of you go to. It's okay to send a quorum to that, because that's not technically a meeting. Again, I would caution you about, don't all of you sit around at dinner and start talking business and plot the plan to fire the president when you get back, because eventually that's going to come out and it's going to look bad. So one the legislature added, I think last session, not this most recent session, but in 2015, is a quorum of you can go to the legislature to testify before a legislative committee. And that was just a problem because more and more of us at the local level are trying to activate and show up at the Capitol and let them actually hear from those of us that are doing the work instead of just the lobbyists that are telling them what they think the law should be. And it became a problem because sometimes a quorum of you want to show up. Maybe there's 5 or 6 of you that actually want to testify, or one of you is going to testify and you want the other 5 to stand up to show solidarity. That was technically a meeting until the legislature changed the law a couple of years ago. So now you can testify in front of a legislative committee and it's not a meeting. So again, in all these circumstances though, you're not supposed to sit around and make plans for what you're going to do at the next meeting or how you're going to take over the board or that kind of stuff. So try to keep that, tamped down. The closed sessions and executive sessions, for the most part, your staff and your attorneys are going to handle what you can talk about in closed session and what you can't. I'll just say for your purposes, if you're running the meeting and you're going into closed session, you have to announce each of the sections of the law that the exceptions that you're going into closed session for. So if you're going to go in there to consult with your attorney about some litigation and a settlement offer that's been received, you need to say we're going in under section 551.071. If you're going in there to talk about the president's evaluation, you need to say we're going in under 551.074 to talk, or 072.4 to talk about the president's evaluation. If you're going in to talk about real estate, that's 072. So that should all be on a script that you're given. I mean, hopefully, if it's not, and you're running the meeting and it's your first time ever running a meeting, you might want to run to the lawyer and say, what am I supposed to say when we're going into closed session? Because if you don't say that, you can get into trouble. So we have to post our meeting agendas on the internet now, and you have to post the materials on the internet. If you're a junior college, which is what the law calls us, I guess we're all community colleges now. I don't think anybody's a community college or junior college anymore. They haven't changed the education code. So if you're a junior college district and you have more than 20,000 students in total enrollment in any semester of the prior academic year, you have to broadcast your meetings live over the internet. And then you have to archive them and keep them available on your website. One thing the legislature didn't tell us is how long we're supposed to archive them or for how long we have to keep them there. And I guess someday they'll get around to telling us, but for the time being, the advice is you keep them permanently on your website. So they'll get around to letting us know those things. So a lot of boards have broken up into subcommittees, and as long as the subcommittee is not taking any final action, you don't have to post it. Because it's not a quorum, hopefully. If you're doing it right, you're not sending a quorum of people to go talk about a topic. If you do that, though, and enough of the other board members show up at the committee meeting because they're interested in the budget you're working on or they're interested in the student effectiveness report, that becomes a meeting, and then it has to be posted. So again, you need to have some communication with your president or whoever your liaison is to the staff to say, I'm planning on going. You might want to remind them there may be more of us there. It could be a quorum. You might want to check, or you might want to just, again, we'll do that posting. We'll make it a meeting at that point so the public could actually attend. If you have advisory committees and a couple of you are serving on it, again, that's not a meeting because you're not a quorum. But again, if enough of you are going to show up and it becomes a quorum, it has to get posted. If the advisory committees are a process you've used for years and the board just rubber stamps it, there are lawyers, including the Attorney General, who will say, that's a meeting. Even though it's an advisory committee, it's mostly citizens and maybe one or two elected officials, but if the whole board just routinely votes yes on what they do, the Attorney General, in a very, sharp position on I want everything open, is going to say that's probably a meeting too. So you have to be careful about that if you use subcommittees and advisory committees, that there actually be some discussion and debate about what they bring back. You have to go through training. Hopefully all of you who were elected in either November of last year or May of this year have done it. You have 90 days to take a Attorney General required training on open meetings and a Public Information Act, which we'll get to in a minute. So if you haven't done that, please do that. There's no penalty for doing it, for failing to do it, but there's a requirement at the community college level at any rate that we have to have I guess it's at the four-year university as well. You have to have a report at the end of every year about whether all trustees have completed their mandatory training. And it goes into the permanent record. There is a permanent record, it turns out. They weren't lying in kindergarten. It goes into the permanent record of the organization that you didn't do your training that year. So you probably don't want that to happen to you. So what are the troubles? The troubles are that violating this law is a criminal offense. It is punishable by a fine of up to $500, which doesn't sound too bad. And maybe some of us are risk takers and we're willing to gamble. But you can also go to jail for 6 months. So I don't know anybody that's willing to go to sit in county jail for 6 months because I absolutely had to go talk to a quorum of the board about something. So it used to be that we could say, nobody really gets prosecuted. There are a lot of people being prosecuted for this now. The county judge in Smith County, which is Tyler, was indicted back in 2016 for conducting closed meetings that were illegal. It went through a lot of movements back and forth about what was going to happen. Ultimately, he pled guilty to one of the charges, paid a $200 fine, and resigned from office. And that just happened right after this conference last year, actually. It was in November, at the November 4th meeting of the Smith County Commissioners Court. They accepted his resignation. So that was one I actually mentioned last year, so I wanted to follow up and tell you about that one. A really interesting one that's been going on is in Montgomery County, which is just north of Houston. Think Woodlands or Conroe. The county judge and I think two of the county commissioners were indicted back in 2016 for conducting illegal meetings. They were trying to develop a bond package for the county. They had one defeated recently. They were unhappy about that. There was a group, I think a Tea Party Patriots type group, that actually defeated it, so they wanted to meet with those individuals and try to figure out what they didn't like about it. And they held meetings on a fairly regular basis where the county judge and one or more of the other commissioners would rotate in to talk to these folks about what they wanted, and then they called their bond package, which passed, so it's good news. But then they got indicted. So their trial actually began earlier this year, and their lawyer, they hired Rusty Harden from Houston. So, if you ever get in trouble like this, call Rusty. He apparently is the best. He managed to get the judge in that county. He was appointed. He was a visiting judge because none of the judges in the county wanted to actually hear the case against, the county judge who helps set their budget. So they brought in an outsider. But Rusty Harden managed to convince that gentleman that the portion of the Texas Open Meetings Law that makes it a crime to conspire to circumvent the law is too vague and is constitutionally vague and therefore violates the Constitution. And this judge in Smith County, or in Montgomery County, made that declaration, which theoretically guts the entire law, and you can go do whatever you want. But that's been appealed. It's at the Ninth Court of Appeals in Beaumont. It'll be heard by that court January 25th of next year. So depending on what they do, it may get appealed again. It could go to the Court of Criminal Appeals in Texas. Depending on what they do, it could go to the U.S. Supreme Court. So there are people challenging this law because it is rather technical. It is sometimes counterintuitive about what you can do and not do. I don't know that gutting the law and making it, a free-for-all is the way to go. But that's where we are right now in that case. So that's in Montgomery County. Shifting to the other side of the state, we'll go over to El Paso. The mayor of El Paso and I think 2 or 3 council members are being investigated by the Texas Rangers for violating the open meetings law by holding meetings with a citizens group because they were going to put a stadium or an arena in a certain part of town, the people who lived in that part of town didn't want it there. And apparently, based on surveillance camera footage, which you might want to begin thinking about, they have date and timestamps of when the citizens would go to the county judge's office and when the mayor's office, and when certain council members would go into that meeting and when they would leave, and other council members would go in and then they would leave. So the Texas Rangers have recently completed their investigation and given it to the DA there. So we'll find out what happens to them. On a slightly less ominous note, 3 council members in Amarillo who were elected in May of this year, and we're very happy about being elected, apparently attended a meeting the city had set up to, they're trying to figure out the direction they want to go with their economic development, so they hired a consultant. So it was a city-sponsored meeting. And these 3 new council members, in their zeal to learn everything they could about what's going on in the city and have an impact, showed up at that meeting. Well, that was a quorum. And nobody's indicting them yet, but the newspaper ran a nice big story about it, that, they've been in office 2 weeks, they've already broken the law, how is this going to turn out? So even if you're not going to get indicted and go to jail, you might want to think about how it looks. Do you want your name in the paper? Do you want your kids to have to go to school and explain why their mom or dad is, potentially a criminal? And then just closer to home, the City of Austin City Council has already this year in civil cases been declared twice to have violated the open meetings law, and their actions have been voided, which is one of the consequences of violating the law in the civil side. Nobody goes to jail, but whatever it is you did gets voided. So twice they've granted zoning to somebody. Twice Bill Elshire, who's a former county judge here, has sued them and said, you didn't tell anybody you were also going to waive all your development fees, or you're going to waive the requirements of environmental protection ordinances, and so far the trial courts have agreed with him, and so twice he's beaten the city on that. And then just to kind of segue quickly into the last part, which I'll have to move fast through, back in 2012, the Austin City Council was accused of having illegal meetings because the mayor would meet with the whole council in groups of 2 prior to the meetings. So every Thursday before their meetings, they would come in groups of 2, I guess, to talk about what they were going to do in the meeting. Somebody noticed that, they reported it, it was being investigated. The county attorney asked for all kinds of information from them, including text messages, emails. Well, it turns out that the Austin City Council used to, not the current one, because we replaced all of them with a whole new system, but they would sit on the dais and instant message and text message each other about how annoying this person was that was speaking, or can you believe they keep coming back and dragging this junk in front of us, and being very snarky and crappy to people. So first of all, that all came out in the paper, so that's interesting. But the district attorney, or the county attorney here, David Escamilla, concluded that those were also meetings. So while they're having an actual meeting with an agenda, they were having illegal meetings talking about stuff that wasn't on the agenda, because they were busy texting. And so we always caution people, if you have to make a phone call or text somebody while you're on the dais, step to the back, go out of the room. My wife used to watch our council meetings on TV, and she would text me and tell me to quit yelling at people, or, don't talk so much, which was good advice. So I'm kind of sad that I have to keep my phone in my pocket now, because I'm pretty much free to do whatever I want to do. So that brings us to open records, and I'm just going to quickly throw out here, I don't want to take all of Donna's time. If it's maintained on any device, see, it used to be it was paper, right? It was this stuff here. This was a document. This was an public information. Now it's anything. Text messages, emails, internet postings, those are all part of the definition now, if they talk about official business. So one of the things that's going on in El Paso, besides their issues with the surveillance footage of people going in and out of the mayor's office, people have asked under the open records law for their personal phone numbers, text messages, their personal emails, text messages that deal with official business, because that's what this law means now. So if you have a public account, you have a college or university email account, or a college or university issued phone, nobody's going to argue that that stuff's probably public. But if you're sitting at home using your personal email or your personal telephone to talk to other members of your body, that also now is going to be public information. And the conundrum that's happened, which is, I think, fascinating and highly predictable, is those council members are just refusing to turn it over to the city. So the city has a duty to respond to the open records request and give them the stuff. But if the city doesn't have it, it's not like we're going to send the police to their house to snag their phone and bring it in. So we're at this point now where I'm assuming the legislature is going to have to step in and put on some penalty for failing to give your information to the governmental body. So that's the sort of the long and short of what I have to talk about today. It's really technical stuff. It's not very sexy, as it were, but it could land you in jail. It could land you on the front page of the paper, which is neither of those things are good things in my opinion. And just be very cautious. If you have questions, like I said, look at the Attorney General books, your handbooks that you're given. Talk to your lawyers a lot. Talk to your administration. The administration can help you a bunch, because we can solve a lot of these issues under open meetings by just posting stuff. And it doesn't hurt to post it, and it's not a bad thing to post it. So please help us help you, as it were. And now Donna's going to talk about more important things.